This conference will now be recorded.
Welcome to Pro Bono's unemployment training, overpayments, and COVID-related issues. It's part of our collaborative project with New Hampshire Legal Assistance and the Legal Advice and Referral Center. I'm Ginny Martin, Pro Bono Program Director, and I appreciate all of you stepping up to help out with this important need that many low-income people have these days for representation with this very important issue around unemployment insurance. Our main presenter today is attorney Ray Burke. He's co-director of NHLA's Benefit Law Project. He has been specializing in issues involving the CARES Act, including those involving unemployment insurance. We also have attorney Steve Tower, who presented at our first unemployment training, who will make himself available during the presentation as needed. And Steve has done many of these cases at New Hampshire Legal Assistance and at prior positions. Before turning over to Ray, just a few more details that I'd like to share with you. Some of you may have attended the first webinar in June. Others may not have been able to do that. You can access this training, I think it's about an hour and a half. You can access it for free if you go to the bar's website, the CLE catalog, and get into the catalog, and it's under Pro Bono Program. So if you click on that, I think the first program that you're going to see listed is the June unemployment training. We did not see the huge influx of cases for representation during the summer for some reasons that Ray may get into. Of course, now a lot of these people have been unfortunately seeing that they're found to be overpaid in benefits these days. So we're really witnessing a spike in those kinds of cases. And I want to say again that Steve and Ray are available and ready to answer questions by phone call or email, and we'll give you their contact information later. One other point that I want to, and all of you know this, that by attending the training that you have agreed to accept a pro bono unemployment case. Some of you have already done this. The pro bono staff, and they're on the video this morning, who you would be hearing from are pro bono coordinator Carol Ann Wooding or Lila Boagian, who is working with us thanks to CARES Act funding from the governor's office. We currently have about 6 clients who need representation. We have a weekly case review with New Hampshire Legal Assistance and the Legal Advice and Referral Center, and we try at that point to divide up the cases that are coming in. Please answer Carol Ann and Lila's calls and emails. We know everyone is super busy, but if you could please take the time to do that shortly after you hear from them, that would just really be great. At this point, I want to turn the training over to NHLA attorney Ray Burke, who has prepared a PowerPoint. I believe that Cheryl sent out the PowerPoint to anyone who registered in advance for the training. So, Ray, thanks.
Thank you, Ginny. Thank you for that introduction. It's great to be talking to everyone this afternoon. Before I get in, one housekeeping item on my end, given these times we live in, I was not able to do this presentation from my office, so I apologize in advance if you hear any toddler noises or dog barking in the background. My hope is that that will be kept to a minimum, but just wanted to ask for your understanding in advance. So with that out of the way, really wanted to echo some of what Ginny just said, that we really appreciate your interest in this important issue, your commitment to pro bono. This is really, as Ginny mentioned, a critical time for pro bono unemployment advocacy. As you probably saw in the blurb about this presentation, the state has been trying to recoup about $25 million in benefits from unemployment claimants that were allegedly overpaid during this time. And we're just seeing a really large number of requests for assistance that both we and our colleagues at LARC cannot meet with the resources we have. So we are really thankful for the partnership with Pro Bono during this time. It's really allowed us to serve more people who we otherwise would have had to turn away, and likely without even some basic advice. And wanted to note that a lot of the clients we're seeing, unemployment benefits are really their only source of income right now. And so your commitment and assistance to helping take on these cases will not only provide much needed assistance for them, and could reduce a substantial debt that would otherwise put them in a deeper financial hole, as we'll talk about with these overpayments today. But the significance of this work really does go beyond the obvious financial impact. You might have heard on the news, on the radio just the other day, there was a report about the significant impact that unemployment insurance benefits have on health outcomes. There was a study done that showed the loss of unemployment insurance benefits was linked to poorer health outcomes. And so again, really just wanted to mention, we really value your commitment, and this is an opportunity to really make a difference for folks. As Ginny said, today's focus is going to be on unemployment overpayments. Some of the early slides, for those who attended my colleague Steve's prior training, might cover some of the same ground. We just wanted to make sure that everyone was starting from a similar position as we talk about overpayments. We'll go through kind of the different programs that now exist as a result of some of the legislation and executive orders that were passed to address the impacts of COVID, and then dive into specifically overpayment issues. But as Ginny mentioned, if you're looking for more information than what's provided on the basic eligibility, really echo and encourage you to echo those words and encourage you to check out that earlier training. Again, before jumping in, just want to note that this really is right now an evolving practice, even for us at NHLA. The CARES Act created several new programs to address the impacts of the pandemic that didn't exist before. And as we'll talk about, there's some tension in the eligibility requirements for these new programs with kind of the traditional unemployment eligibility rules. And so at each point throughout the pandemic, our practice has kind of changed. We're seeing new issues pop up every so often. It's causing us to dive in and do some research into these new CARES Act programs that we hadn't yet focused on because we just weren't seeing those types of cases. And right now we are clearly in an unemployment phase. I think the vast majority of cases that have been coming in the last couple of months have all been overpayment cases. We're not really seeing too many initial applications for assistance or issues with certifying their weekly claims and maintaining eligibility. The U.S. Department of Labor has been putting out guidance regularly about these programs, so just wanted to note that. We'll reference some of those as we go through. For a while early on in the pandemic, it seemed like guidance was coming out every couple of days, and then every couple of weeks. It slowed down a bit, but there is still guidance and changes happening. And also just wanted to make a note at the outset that there could be further changes that we're not yet aware of today. The information we're providing to you is accurate as of today, but you've probably seen lots of talk in the news about another relief package potentially being passed by Congress. And if that happens, there's talk of some modifications to some of these programs we'll be talking about today. So may be an opportunity for another training down the road if that happens, but wanted to at least let people know about that, because you'll want to make sure when you do take on a case, if a relief package has passed, that you understand what differences might exist as a result of that. Let me see here. So I'd like to turn now just to, again, give a brief overview so we all are understanding what programs we're talking about and what's what the new programs are. So this first slide lists the unemployment programs that existed before the pandemic. So we have what people typically refer to as just state unemployment insurance program, which was a big focus of Steve's prior presentation. That can provide up to 26 weeks of benefits for eligible claimants. But we also wanted to mention two other programs that you might hear about throughout the presentation and in the course of handling a case. And that is the Extended Benefits Program. This is a program that existed before the pandemic, but it's not always in effect. It's benefits that are available to workers who've exhausted their eligibility, their 26 weeks of regular or state UI benefits, and it happens during periods of high unemployment. So depending on what the what's going on in the state with our rolling unemployment average, claimants may be eligible for up to an extra 13 or 20 weeks of benefits after exhausting their regular UI. We just received word that the state will be triggering off of extended benefits tomorrow, actually. Going forward, it won't be an option for people to receive benefits unless the unemployment rate changes. But the reason we wanted to at least highlight it is you may see overpayments involving these benefits, because many people were receiving extended benefits going back to over the summer when the unemployment rate was so high that the state triggered on to the extended benefit program. And then lastly, I wanted to just say a quick word about disaster unemployment assistance. These are benefits for individuals who are unemployed as a direct result of a major disaster. We don't currently have those here in New Hampshire, but the reason that I mention them is the regulations that govern the DUA program do apply to one of the new CARES Act programs, Pandemic Unemployment Assistance. And so you may see some reference throughout the slides to some regulations that are part of the DUA program, but under the CARES Act, they also apply to PUA. And now turning to the new unemployment programs, there's actually, I believe, more than just this list, but the reason I wanted to highlight this list is because these are the programs we deal with mostly in the cases we see. So the most common one that I already alluded to a moment ago is the Pandemic Unemployment Assistance Program, or PUA. And this is a program that provides benefits for claimants who are ineligible for state UI and are unemployed due to a qualifying COVID reason that's listed in the CARES Act, and we'll talk more about that in a moment. Claimants can receive up to 39 weeks of PUA benefits. There is some interaction with the other programs. We won't be diving into all of the details today, so it's 39 total weeks of benefits, but if the claimant was ever eligible for a different program before enrolling in PUA, those weeks would count against that 39-week total. So it's not 39 weeks in addition to the weeks of eligibility for regular UI. The next program is Pandemic Extended Unemployment Compensation Benefits, or PEUC benefits. And this is sort of similar to the Extended Benefit Program. It provides an additional 13 weeks for claimants who have already exhausted their eligibility for regular UI. And folks are supposed to receive PEUC benefits before they would have received extended benefits. So you would get 26 weeks of regular UI if you were eligible, then potentially 13 weeks of PEUC benefits if you continue to be eligible. And then if you reached that point, you would get another 13 weeks potentially of extended benefits, again, up until this week when the extended benefit program is ending. Excuse me. And there's two other programs. Oh, and sorry, before I move on, both PUA and PEUC are ending on December 26th of this year unless Congress acts to extend those programs. There's a big push for Congress to extend those programs given everything that's going on and that COVID cases are surging. But as of today, folks cannot receive benefits through those programs after December 26th. I think the reporting that I've seen, I haven't been able to pay a lot of attention to it, but I think those programs would get extended in the bill that's being debated, but we'll just have to see how that plays out. The last programs that I wanted to mention, these are programs that have actually already ended, but again, you may see reference to them when you're handling an overpayment case because a lot of claimants did receive these benefits over the summer and in early September. So the first program is the Federal Pandemic Unemployment Compensation Benefits. I often refer to them as FPUC. When we talk to the folks at Employment Security, they often refer to them as FPUC. For some reason, I just can't get myself to say FPUC. So, but that's how we've heard folks at Employment Security refer to it. This was the enhanced benefit that was passed by the CARES Act, the extra $600 per week for claimants who are eligible from April 4th to July 25th. One thing to note about this program is that it was for people who were eligible and were receiving at least $1 of an unemployment benefit. So it didn't matter which program someone was eligible for. It could be regular UI, PUA, PEUC, extended benefits. As long as they were eligible and receiving $1 of an unemployment insurance benefit, they would get this extra $600 per week for all those weeks of eligibility. And we'll return to this later on when we talk about overpayments, because a large portion of the overpayments that we're seeing right now involve these FPUC benefits. $600 per week is a significant additional benefit on top of what people normally receive. The max benefit someone could otherwise receive absent this program would be $427 per week. So when people are alleged to have received an overpayment, the bulk of the overpayment is often going to be these FPUC benefits if the time period in question is between April and July, which are a lot of the cases we're seeing. And all three of the programs I've talked about on this slide up until now, PUA, PEUC, and FPUC, were all created by the CARES Act. The last program on this list is different, the Lost Wages Assistance Program. This is a program that was created by President Trump's executive order to try to address the fact that Congress didn't pass another relief package after the FPUC benefits expired. And so certain eligible claimants could receive an extra $300 per week between July 26th and September 5th. This program was a little different from the FPUC program. Not everyone could receive it. For FPUC, it didn't really matter your reason for being unemployed and what program you're receiving. Again, as long as you received $1, you would get the extra $600 per week. For this Lost Wages Assistance Program, you had to be partially or fully unemployed due to COVID, and you have to have received at least $100 per week in unemployment benefits. That last piece about the minimum benefit of $100, that is no longer really an issue. Governor Sununu temporarily raised the minimum weekly benefit amount during COVID in order to maximize the benefit that people could receive through this program. But I wanted to list it there just so you had the broad eligibility rules. Another note here on this program is that being unemployed due to COVID for purposes of lost wages assistance is different than being unemployed due to COVID for PUA. And again, we'll go over this a little bit more in a moment, but wanted to note it here. For the PUA program, the CARES Act lays out specific criteria for someone to be eligible. But on lost wages assistance, it's a little more broad. It's really just unemployed due to COVID and have experienced a loss of employment due to, I think the language says, a disruption due to COVID. So that's just important to flag. So right now, I'd like to turn to giving an overview of the two main basic programs. This is where some of the information from Steve's prior presentation, overlaps with this. But again, I wanted to make sure everyone who might be participating in this presentation without having participated in that prior one had the basic information. So for state unemployment insurance benefits, there's a couple of things to highlight. First, there's a monetary requirement. Claimants must have earned a certain amount of wages in what's called the base period. And there's a base period and an alternative base period, and we provided the site to the RSA here. But for purposes of our presentation right now, wanted to mention that if someone doesn't meet this monetary eligibility requirement, then they're denied. They can't be eligible for regular or state UI. Second, the weekly benefit amount that someone could receive if they are eligible is calculated based on those earnings in whatever the applicable base period is under the RSA. And as I mentioned a moment ago, the minimum weekly benefit amount has been temporarily increased by Executive Order number 68. So the least amount of weekly benefits someone could receive at this point in time is $100 per week until that executive order is rescinded. Previously, the minimum that someone could receive under state UI was a lot lower, $32 per week. And in really just general terms, to be eligible for regular UI, someone must not have left work voluntarily without good cause, and they must not have been discharged for misconduct connected with work. So some of the overpayment cases we're seeing are due to the fact that someone was determined eligible initially based on the information Employment Security had for state UI, but then months later, Employment Security, for some reason, learns of new information that wasn't available at the time, or maybe in auditing cases, they realized they had the information, but they reached the wrong decision. And so someone may get a notice that says, you were overpaid benefits because you actually had a voluntary quit. You voluntarily left work without good cause. And even though we initially determined you eligible, we now realize it was a voluntary quit. And so you were overpaid for all weeks that you received benefits. So that's why we wanted to highlight the standard here. Again, sorry if I'm being repetitive, but for more information on those standards, please refer back to Steve's prior presentation. Now I wanted to turn to the basics for eligibility of the PUA program. There's no earnings requirement, so it doesn't matter what someone earned prior to being unemployed. In fact, someone may not have any earnings in the base period and can still receive PUA benefits. Another important difference is a PUA application can be backdated. So for regular UI, when someone applies, they can only receive benefits based on the date of their application going forward in broad terms. For PUA, it can go back to their date of separation. So if someone somehow didn't apply until today and they didn't know they were eligible for PUA, but they were, and they had a separation that happened back at the end of March because the employer closed down due to COVID and never reopened, in theory, that person could apply today and ask for retroactive benefits back to the end of March or beginning of April. The base period for PUA is the calendar year 2019. This is an important distinction from regular UI. On the previous slide, we had the cite to the RSA about the base period for regular UI, and it really depends on when the person is applying. They look at the previous 5 quarters. For PUA, it's 2019, so basically all earnings in 2019. And for self-employed individuals, there's an important point here. Their weekly benefit amount is calculated based on net income on their 2019 tax return during that base period. This has caused some issues in overpayments that we can talk about more in a moment. Some people, when they applied initially, they hadn't filed their taxes yet, so all they had was their gross income. And depending on how their case was handled, that may or may not have caused problems for them down the road, because of course their gross income is generally going to be higher than their net income. So if they were approved for a weekly benefit amount based on their gross income, they may receive an overpayment because down the road, Employment Security became aware of their net income and then retroactively reduced their weekly benefit amount. The minimum PUA benefit that anyone can receive in New Hampshire is $168. So this is another important distinction when you compare it to state UI. Regardless of what the person's earnings were, that's the minimum they can qualify for. If their earnings make them eligible for a larger amount, they can receive up to the maximum, which is $427, but $168 is the minimum. So usually if you see that someone was receiving $168 per week, it's not guaranteed, but chances are these days it's likely they were receiving PUA benefits. To receive PUA, a claimant must be ineligible for state UI, PEUC, and the EB program. So PUA is sort of a program of last resort. Early on in the pandemic, we were seeing a lot of issues where claimants were clearly eligible for PUA, but their case was being held up because they received a denial of their application for regular UI and they requested an appeal. And the department was taking the position that they couldn't determine their eligibility for PUA until their eligibility for regular UI was fully adjudicated. That still comes up from time to time. You may, in the overpayment cases that we're seeing, see someone who was receiving regular UI, they were determined overpaid, and they're trying to dispute that. And when we evaluate the case, we say to them, oh, you actually, it's correct, you were overpaid UI, regular UI, you were ineligible, but we believe you have a claim for PUA. So the best way to resolve their particular situation might be to ask the department to process their eligibility for PUA, and I'll talk more about that in a moment. As I mentioned earlier, mentioned it again here, under the current law, PUA is not payable for any week after December 26th. Sorry. Okay, so here's more about the eligibility for PUA. A claimant must self-certify that they are partially or fully unemployed or unable and unavailable to work because of one of the following COVID-related reasons or circumstances that come from I'm not going to run through all of these. I'm different, but I'll highlight a few that we see common early in the pandemic that we now. Sorry for a moment. I'm getting a message that my network connection is. I apologize, but Doreen, I might ask you. It's asking if I want to turn off my webcam. I guess preserve speed. I don't know if I just keep going. Actually, I should do that. I'm not sure if the connection's been interrupted there. Or Ginny and Steve, see you. Can you nod your head if you can hear me?
Yeah, I do see some slowness there. Okay. So yeah, if you want to, let me just see if I can detach the camera here. Okay.
I will ignore this then. Okay, maybe that's okay. Yes. Apologize for these technical difficulties.
There we go.
We seem to be able to hear you now.
Yeah.
Should I keep going?
Oh.
Okay.
Yep. Oop. Okay, I'm not sure what's.
Okay, sorry about that, everyone. So the criteria that I wanted to highlight here, people risk. for complications that would result from COVID. So these are folks who have underlying health conditions that would put their life at risk if they were to contract COVID, and that they should self-quarantine and to be the claimant has self-certify to this. But when a claimant has an issue with eligibility, if they've received an overpayment notice, it can be helpful to obtain documentation from their medical provider to verify that they do indeed have put them at greater risk. Health conditions that the other criteria that we see. So just give me a moment to try to find it. Yes, it's this last bullet point on this slide, and that is parents who are unable or unavailable to work because their child's school is only offering a remote learning option, and so they need to be in the home to take care of the child. That's another common issue that we frequently see these days. Through that, the sound is pretty choppy. Doreen, it looks like I saw a chat. Should I pause again or okay to keep going?
I'm hearing you fine right now. Are other people still having difficulties with hearing?
He's going in and out. To me, he's going in and out. This is Heather Burns.
Yeah.
Okay. One message in the chat, so that's why I just wanted to pause and make sure I wasn't.
Yeah, so I think if I had disabled your camera, so I'm not sure why it's
okay, I'll turn that off again and see if that helps.
Okay, try that.
Can you still hear me okay?
Yes.
Yep.
Okay, great. Yeah, I'm not sure if it's my connection. I'm hardwired into the internet here at home, but it does seem like there might be some delay even on my end, because I'm hearing a little bit of a delay in your responses, but I can hear everyone. Okay, looks like some folks are saying that's better, so I'm going to go ahead and proceed. Again, apologies for the technical difficulties. I have been advised to self-quarantine by a provider, so I would meet the PUA criteria if I did not have the option of working remotely from home. That is why, unfortunately, I'm not in the office today. So again, just to pick up, this was meant to give you a quick reference to the criteria for eligibility for PUA. We referenced the statute on one of the previous slides. Before we break for questions, our first break, I just wanted to mention one important point, and that is for to receive any unemployment benefit, claimants must still be available to work regardless of the program. They have to be ready, willing, and able to accept suitable work. And so this means they have to be physically capable of work, ready to start at and ready to start at any time. Normally, claimants also have to be regularly searching for work. We call it often referred to as a work search requirement. Those are currently waived by the governor's executive order number 5. But there's a lot of confusion among claimants about these requirements, about being available to work. And I think this stems from some of what folks are hearing about the CARES Act programs, and perhaps even the waiver of the work search requirement. So you'll remember a moment ago, we were talking about the PUA program, and to be eligible for PUA, you have to self-certify that you're unable or unavailable to work due to one of those COVID-related reasons. So people, I think, get confused when they're then found to be ineligible or found to have been overpaid because employment security determines that they were unavailable to work. If they don't meet one of those COVID qualifying reasons about unavailability, they still have to be available. So to try to give a concrete example, say someone's employer shut down due to COVID, and that's why the person's unemployed. They would clearly meet a PUA, one of the PUA criteria, and would be eligible. But let's say their job was doing some sort of manual labor, they were a contractor or working for a contractor, and while they're receiving unemployment benefits, they have a health issue, like they say they break their leg or something that incapacitates them temporarily, and had COVID not been an issue, they wouldn't have been able to return to work. That person would actually be ineligible for benefits during any week where they weren't actually ready, willing, and able to accept work, but for COVID. So a lot of claimants, I think, I want to mention this because they're confused about this, and a lot of overpayments we're seeing have to do with availability issues, and so you'll really want to probe the facts of the case, interview the client, and we try to do some of this up front in the intake, but usually there's some more fact development that you will need to do once you get the case. But that's to find out why was the person unavailable? Was it really due to COVID, or was there some other health issue that was getting in the way that caused employment security to determine they couldn't have accepted work if COVID weren't an issue? And so with that, I'm going to pause here for questions. If there's any questions up until this point, I've been trying to keep an eye on the chat. It looks like most of them have been about the technical difficulties, but are there any questions so far about the different programs, their purpose, the general requirement? I don't want to dive too much into the weeds on the eligibility of state UI and PUA because we do want to focus on overpayments, but I'm happy to take any questions and help clarify anything I've said up until this point.
This is Ginny. I'm not seeing any questions. So.
Okay, we can feel free, folks, to type in if for some reason there's a reason you couldn't ask now. We can always get to it at the end or later on.
We have a question now, Ray, from Heather.
Oh yes, yeah. So thank you. Yeah, that's a good question. Yes, so employment security is handling all issues related to the unemployment programs under the CARES Act, and also any issues that came up with respect to the Lost Wages Assistance Program that I mentioned that was created by executive order that technically that funding is controlled or administered by FEMA. So yes, employment security, any overpayments that have to do with an unemployment program, whether it's a program that has always existed or one of the new CARES Act programs, will be handled by employment security. And for the most part, I think this is accurate. Hopefully Steve can correct me if I'm wrong. There's not, there are no significant procedural differences that come to mind as far as, when you receive a determination, when the client receives a determination and disagrees and wants to appeal, generally the same rules around that are going to apply. The eligibility rules might be different and governed by different federal regulations or guidance, but as far as handling overpayments and contesting overpayments, those are all going to flow through the normal channels through employment security.
That's correct.
Thanks, Steve. Steve is our resident expert, as Ginny said, so he's here to help answer the tough questions and catch me if I slip up and lead you astray inadvertently. Any other questions? Okay, I'll continue on, but feel free to keep sending them in the chat. Here's just a high-level overview of overpayments. So overpayments, maybe I should have put this earlier on, but it's a determination that benefits should not have been paid to the claimant that the claimant received. When a claimant has an overpayment, under state law, interest does accrue at a rate of 1% per month. We'll talk more about that towards the end of the presentation. If the overpayment is due to deliberate fault or fraud, New Hampshire Employment Security will assess an additional 20% penalty on overpayments. There are different rules about penalties for the new CARES Act programs. I didn't really get into those in this presentation because we're not seeing many fraud cases. Off the top of my head, I can only think of maybe one or two that have come in during the pandemic, and I think both of them were fraud issues that happened pre-COVID. Non-fraud overpayments may only be pursued within 2 years of receiving the benefits, but 6 years if it is a fraud case. I'll just note here, if you received the slide, I had an error on a previous version of the slide. I had the statute of limitations for non-fraud overpayments as 3 years. Steve and I corrected that this morning. So we will circulate the corrected version of the slides after the presentation. But if you're looking at the PowerPoint that went out to you, yours may say 3, but 2 is the correct number here. Here's just again in broad strokes before we start diving into the specifics, the different ways to handle an overpayment. So first is to appeal and dispute the determination, to argue the merits of the case, that the client was in fact eligible for benefits and therefore there was no overpayment. There's the same appeal deadline exists. The appeal must be received or postmarked within 14 calendar days of the date the notice was mailed. But it can be extended for good cause. We are seeing that Employment Security has been generally flexible in granting these late appeal requests. I think even Employment Security will acknowledge that this has been a really difficult time, not only for claimants, but for the agency to try to administer these new programs. There's been a lot of confusion. Sometimes, despite best intentions, sometimes Employment Security staff has given out misinformation, and so we're finding that generally Employment Security is being pretty flexible with that deadline, though we always advise clients if they are requesting an appeal outside of the deadline, they should still try to explain the reasons why the appeal is being submitted late. Also can note here, there are significant delays in processing and scheduling the hearings and appeals. So I think the most recent information we have is that hearings are being scheduled for sometime in January, and they may have even been moved into February by now. And clients who have requested appeals back in October may not have even received an acknowledgement of their appeal request. So sometimes this is also a point of confusion for clients because they've submitted an appeal request, but they haven't heard anything and they're not sure what the status is. Usually when we're involved, if there's a concern about that, we can touch base with the folks in the Employment Security Appeals Unit to try to get clarification on where things stand. They are trying to prioritize cases to some extent based on need. So if it's a client who has no income and this issue is really creating significant concerns for them as a result of the loss of benefits, that may be a reason where we could ask Employment Security to bump it up the list. But otherwise, it could take some time to get the hearing acknowledged and scheduled. So apart from disputing the determination and the merits of the case, claimants can also request to have their overpayment waived. And we'll talk more about this in a moment. There are different standards, but basically waiver is when there's an acknowledgement that there was in fact an overpayment, but based on the standards that apply, Employment Security can waive the overpayment and they won't try to collect it from the claimant. If waiver is not an option, there's another way to try to reduce or forgive the debt, and that's to request a claim compromise. And we'll talk more about that in a moment as well. If all else fails, if there's can't dispute the overpayment, or if the claimant receives an unfavorable hearing decision, if their waiver request is denied, and their claim compromise request is denied, and none of those present an appealable issue, the next best option is for the claimant to try to negotiate a reasonable repayment plan. And we'll talk more about this again as well, but if they're receiving ongoing benefits, so say it was just an overpayment for a discrete time period, but they're still eligible now, the overpayment can be recouped partially from their benefits. And as a very last resort for some claimants, bankruptcy is an option depending on their situation. We're not going to cover that in detail here, but because of the enhanced unemployment benefits that were passed from through the CARES Act, we are seeing claimants who have, upwards of $20,000 in overpayments in total overpayment that the agency is trying to recoup. And depending on their financial situation and maybe the other debts they have, bankruptcy might be an option. We often, well, not often, but we occasionally consider representing clients for bankruptcy when they're facing these kinds of debts, or a similar situation would be overpayments of Social Security benefits, which could also add up quickly. So I want to turn to the standard for requesting a waiver for a moment. Again, I mentioned this differs for different programs. For state unemployment insurance benefits, it's pretty straightforward, and I included the citations to the RSA and the regulation here, although I just see now I left off the RSA letters. But the claimant is not liable for an overpayment, to repay an overpayment of state UI benefits if they were without fault in causing the overpayment. Employment Security does a pretty good job of trying to determine whether a claimant was at fault. And so oftentimes the initial notice of overpayment that a claimant receives will indicate whether some portion of the overpayment was waived. And if it was, that's an indication that Employment Security, that would likely be regular UI benefits that were waived, and we'll talk about why, but that would be an indication that Employment Security believes the claimant was not at fault in causing the overpayment. For overpayments of FPUC and PEUC benefits, so again, as a reminder, FPUC is the extra $600 per week that people received between April and July. PEUC benefits are the extra 13 weeks that people can receive after exhausting their regular state UI benefits. These overpayments can be waived if the claimant is without fault in causing the overpayment, and recoupment would be against equity and good conscience. That language, equity and that second prong of the test, that recoupment would be against equity and good conscience, this comes from the CARES Act. It's not in our state statutes or regulations. And I wanted to highlight it here briefly. We are trying to work with Employment Security to develop a standard that we think is most appropriate during the pandemic for this equity and good conscience prong of the test, because states have a fair amount of discretion here. This is not defined in the unemployment statutes, regulations, or guidance. The notices that claimants receive from Employment Security state that against equity and good conscience can be established when you have changed your position for the worse or neglected a valuable right because of your reliance upon a notice that payment would be made or because of the overpayment itself. This appears to come directly from the Social Security statute and regulations that govern overpayments of SSI or supplemental security income benefits. So there is some guidance on that when you're in the Social Security context, and we're trying to determine if we're correct, if that's where Employment Security is pulling this standard. Oops, excuse me, sorry, I clicked the button there. We're trying to determine if that's where Employment Security looked to determine how they're going to evaluate this standard. Employment Security hasn't put out a lot of information about this yet, other than this statement that's in the notice. So I think this is certainly an area where things are a moving target, and we would encourage you to contact the folks at Pro Bono and us at NHLA. We're working on a memo. Our fellowship attorney, who was brought on specifically to help with unemployment issues, is preparing a memo about this standard. And once it's finalized, we would be happy to share that with anyone who is dealing with a case where FPUC or PEUC benefits are involved and the claimant is seeking waiver. We're also hoping to use that memo to advocate with employment security, as I mentioned, to adopt a standard that we believe is appropriate for what's going on with the pandemic and overpayments. But until we get more information, I think that memo would be helpful for making an argument to the agency about why a particular claimant meets the standard. Let me just pause for a moment to think. Oh, so what you'll see sometimes is a claimant will receive a notice that they were overpaid benefits, and part of the overpayment will be waived, but another part won't. And oftentimes that will be because the person received regular unemployment or state unemployment insurance benefits, plus the FPUC benefits, the extra $600 per week. And so because the standards are different, employment security determines someone's not at fault, so they waive the regular UI, but because they haven't yet made a determination about this second prong of the test against equity and good conscience, they haven't yet waived the FPUC portion of the overpayment. It doesn't mean that waiver is not possible. It just, I think, is a function, to be honest, of the fact that employment security is still trying to sort all of this out. This slide contains information about how to request a waiver. So there's a waiver request form that Employment Security recently developed. There's a financial affidavit that they ask clients to provide, and you can submit both to this new email address that Employment Security created specifically to handle overpayments. Our recommendation is that it's helpful to submit a supplemental memo and any other supporting documentation that might help make the case. There's not a lot of room in the waiver request form if it's a to provide detail or even a legal argument, but it's fine to supplement that form. I'm going to pause here because I see a question that I think is worth answering. The question is, if a claimant requests a waiver, does this bind the claimant in admitting they were not eligible for benefits? Steve, I might ask you to jump in, but my thought is that you wouldn't want to request a waiver necessarily if you are going to be going to a hearing to dispute the determination of the overpayment. But if a claimant has already submitted that request before the hearing has happened, I would argue that does not bind the claimant. One of the issues.
I would agree with that.
Steve, just to make sure everyone heard, Steve said he would agree with that. One of the issues that will be heard at a hearing on the merits is whether the person was at fault. So the chairperson who is presiding over the hearing will evaluate the eligibility issue that caused the overpayment and determine whether the person was in fact overpaid or not, but they will also determine whether the person was without fault. So I think submitting the waiver request before the hearing could help provide information about why the person wasn't at fault, but I don't think it would preclude the claimant from arguing the merits. And I will say, oftentimes what we see is when claimants submit their appeal request, or if on the rare occasion they've submitted this form, they're sort of making an argument on the merits in their statements, even if they don't have a full understanding of what the standard is and the eligibility rules. They often will try to make an argument about why they believe they were eligible, in addition to why they can't or should not be required to repay the overpayment. Thank you for that question. There are some limitations on waiver or claim compromise for some of the programs. These are mostly some of the new programs that were created. So unfortunately, under current law, claimants cannot waive or compromise overpayments of PUA benefits or overpayments of lost wages assistance benefits. This is something that national advocates have been trying to ask Congress to address because many states do have waiver provisions in their law. And again, this has just been a very difficult time for state agencies, including our state agency, Employment Security, and for claimants. And so we're seeing some claimants come to us with PUA overpayments where they were clearly not at fault. And I think even the Employment Security would acknowledge that. But because of the regulation that applies, which is a disaster unemployment assistance regulation that applies based on the CARES Act, the PUA benefit overpayments cannot be waived. And it's just a really difficult situation that we're finding some claimants in as a result of this. So if they can't be waived or compromised, unfortunately, the only options these folks have, absent some change in a subsequent relief package passed by Congress, is to try to overturn the determination on appeal to argue that they were in fact eligible for PUA, or to negotiate a repayment arrangement or bankruptcy, as I mentioned earlier. These next two slides, I'm not going to spend a lot of time on, especially given the time, but just provided some information for you here about requesting a claim compromise. So again, this would be done if you lost the appeal on the merits, or there was no argument to be made, and waiver request was denied. Claim compromise sort of gives the claimant another bite at the apple to reduce or forgive the overpayment. A claim compromise can be requested at any time. The request must be sent to the commissioner's office with that same financial affidavit that was on the previous slide, the claimant's most recent tax returns, and again, we recommend a written explanation of why we believe the claimant meets the standard. Claimants receive a written response and they can appeal a denial of a claim compromise request, similar to other determinations, but under the regulations, they would ask for a request for reconsideration first before going to a hearing. This slide is also about claim compromises. It's to include some information for you and some citations for the standard. Compromise is granted when the agency determines that compromise would be in the best interests of the state. There's a rebuttable presumption that compromise is in the best interest of the state if the debtor or the claimant, if their household income is solely based on one of the programs listed here. These are generally means-tested programs administered by the Department of Health and Human Services or Social Security or the Veterans Administration. But that presumption can be rebutted based on factors that are contained in one of the regulations cited here, 408.04b. If no presumption exists, so if the claimant is not relying solely, their household's not relying solely on those benefits stated above, it's a totality of the circumstances test, and you can find the details about that in the regulations cited here, 408.05, and the factors are at 408.06. And there's some more information about this in Steve's prior presentation. So let me pause here. I know that was a lot of information. Are there any questions about waiver or claim compromise? Next, we are going to turn to kind of how to think about a case when you get it and walk through some of the different steps and questions to be asked. But I wanted to make sure we covered some of this information about waiver and compromise before talking about that. So I'm happy to answer any additional questions about those before moving on. I'm not seeing any come in, but please keep typing if you are typing. I'll keep an eye out and I'll pause if I see something, but given the time, I'm gonna keep going through here. So we wanted to, again, go through sort of an anatomy of an overpayment case. What should you do? What should you be thinking about when you take on one of these cases? The very first thing that we do is to review the notices the client received. And again, when clients call us for assistance, we at NHLA and LARC and with our colleagues at Pro Bono, we're going to be trying to do some of this triaging for you before the case ever gets to you. But when you get it, of course, you'll want to review the notices that we've been able to obtain up to that point in time. And ultimately, you'll want to request the entire file from Employment Security to make sure that you have all of the notices and determinations that have been made that are relevant to the overpayment case. Oftentimes, unfortunately, clients either misplace notices, or if they don't have good internet access, they can't access their online claimant portal. And so we don't often have every relevant notice when we're initially triaging a case. And those can be important, again, because there could be various determinations that are relevant. Sometimes the overpayment is the result of one single determination. Other times, Employment Security has made different determinations about different eligibility weeks or different determinations about the different programs involved. And so you'll just want to make sure you have a handle on, the claimant may speak about the total overpayment that they're being asked to recoup, but they may not know to distinguish that total involves separate determinations that carry separate appeal rights. And so when you look at that, you'll want to see, did the client actually appeal all relevant determinations? Again, when a client comes to us and requests assistance, we try to talk about this with them up front, and our intake staff knows to advise them to carefully read all notices they received and to timely request any appeals so they don't miss the deadlines. But again, as I mentioned earlier, during the pandemic, Employment Security has been flexible in granting late requests. And there's a regulation that provides some support for the ability to clarify issues to be heard or to consolidate issues. If say there were separate determinations, the client filed an appeal only on one of the notices without necessarily listing the determinations from the other notices, if those arise from the same common facts and are governed by the same law, I think the chairperson would agree to hear those issues. But that's something to, you would want to try to clarify ahead of the hearing if possible. And you should have enough time to do that given the significant delays in scheduling that are happening because of the volume right now. You'll also want to request the employee personnel file if it's relevant to the case. This may depend on what the issue is. This is most often relevant and most common in misconduct cases. So if someone had been receiving state UI, state unemployment, and Employment Security months later determined, no, you were not eligible because you were actually discharged for misconduct, you'll want to request or have the employee, if you don't yet have a release, the client request the personnel file so you can review what the alleged issue was, what was recorded, if anything, in the file that might be relevant to the case. And you'll want to note the hearing procedures and deadlines that are contained in the regulations at Chapter 200. There are deadlines for submission of evidence. If there's anything, any motions that might need to be filed, that there would be those would be governed by those rules. I think this has been pretty rare in our practice. I can only think of one case recently, but sometimes it can be helpful to request a pre-hearing conference, and you can find the standard and how to do that in that chapter. Next, as you're gathering all this evidence, reviewing the notices, you'll want to ask yourself and try to determine what programs are at issue, what make up the alleged overpayment. Prior to the pandemic, this was pretty straightforward because it was really only going to be state unemployment insurance or maybe extended benefits, depending on what was going on at the time. But right now, during the pandemic, with all the new programs, overpayment determinations often involve multiple programs. So I gave an example here. If someone was receiving regular state unemployment and and they applied at the beginning of the pandemic and have been receiving it the entire time or for some significant length of time, they're likely going to have an overpayment of state UI, the FPUC benefits, the extra $600 per week, and lost wages assistance benefits, the extra $300 per week if they met the criteria and were receiving benefits through September. And again, this is important because of what we spoke about earlier. There's not only different eligibility criteria for these different programs that would have to be met if we're trying to dispute the merits of the case, but then there's also, importantly, different standards and limitations on which programs overpayments can be waived. And as you're trying to analyze the case, the first question that we've talked about a lot already is was the client actually overpaid benefits? Are there any arguments to overturn the determination? So if Employment Security is now saying that the client was ineligible for state UI, for example, because they voluntarily quit their employment without good cause, you'll want to ask, was it really a voluntary quit? We have had some success in overturning these determinations. Recently, I can think of a case someone had where there was misconduct involved, and the case was overturned because it was determined at an appeal that it wasn't misconduct. And again, for more on those standards, would really encourage you to check out Steve's prior presentation. Just wanted to give you a brief example here. Another big question we always ask ourselves nowadays when we see these cases are, was the client eligible for PUA? Did they meet any of the PUA COVID criteria? It may be that at the start of the pandemic, the person was eligible because their employer shut down due to the stay-at-home order, and that's the reason they received benefits. But once the stay-at-home order was lifted, it might be that they were advised during that time by their medical provider to self-quarantine because of their underlying health conditions. And depending on what information they provided to Employment Security and how they answered the questions during their submitting their weekly certification, maybe there was a problem there, and Employment Security isn't aware that their medical provider advised them to self-quarantine. Or maybe their child's school started out with in-person classes, but now is going remote, and they need to be home to take care of their child because they don't have any other childcare while the school is closed, and they would be eligible for PUA from the date that they needed to be in the home for that reason. Another big issue that comes up when we're talking about the merits of the case is the availability to work issue that we were talking about earlier. We're seeing a lot of cases where Employment Security is saying someone was overpaid because they were unavailable due to an illness or injury and would not have actually been able to accept work that was offered to them. But again, big question to ask is, were they completely unavailable, or is it just a matter of they are high risk and have to self-quarantine, so they refused work based on the advice of a medical provider? Is there any medical documentation that they could provide? Or again, sticking with these are just the common examples we see, did they refuse an offer of employment because again, they have to be in the home to take care of the child while the child's remote learning and there's no option for in-person schooling, or the daycare is closed due to COVID, as my wife and I are experiencing right now. Similarly, if the client refused work and the determination is that they were overpaid because they turned down work, it's important to ask, was the work suitable? There may be situations where a client, because of their underlying health conditions, could do some work. Maybe if they were able to work remotely from home, that would not be a problem, but they couldn't be in a store or a restaurant or another business interacting with large groups of people in close proximity indoors because of the risks. So, was the work suitable? What does the client have a PUA COVID related reason for refusing to work? Wanted to make a note about self-employed individuals here, and I think we referenced this a little early we are seeing a trend, small trend, I think, in recent cases coming to us of self-employed individuals who were initially approved for PUA benefits. In general, prior to the pandemic, most self-employed folks were not eligible for regular UI or state UI, excuse me, but the CARES Act and the Pandemic Unemployment Assistance Program changed that. So many self-employed individuals were approved initially, and now Employment Security is saying they're ineligible. They were ineligible because of some reason that came to light. And these are the tough cases I mentioned because PUA can't be waived, and so it really does turn on whether the person was eligible. And the issue we're seeing is that, and this is going to get into the weeds for a moment. There's more on this in the guidance and the regulations that we reference here, but for self-employed individuals, you might remember early in the presentation I said Employment Security looks at their net income on their tax return for 2019 when determining what their weekly benefit amount is. So if they had after taking the applicable deductions, when they filed their taxes, if their net income was much lower than their gross income, or maybe they showed a net loss, they would potentially receive the PUA minimum. Certainly if they showed a net loss in income, they would only be eligible for the PUA minimum of $168 per week. But what's happening is Employment Security is looking at folks who are showing a net loss in their 2019 tax return and saying you were ineligible because you had a net loss of income and you couldn't possibly have been relying on that income, to meet your basic needs, and so you did not lose work or income due to COVID. And we think this is an incorrect interpretation of the CARES Act, the DUA regulation, and the applicable guidance. Again, the net income and the net loss of income should only impact the amount of their weekly benefit amount. Whether they lost work or income due to COVID, it doesn't really matter what happened in 2019. We would have to look at the facts of what happened in early 2020 when the pandemic hit. And so we see clients where they have proof that they lost customers. They were expecting payment for whatever service they provide, and they either had to refund some payments that were already made, or the contracts fell through, or the customers they were relying on, their businesses closed, and so that expected income didn't come through. We would argue that clearly means they lost work or income due to COVID, so they're eligible for PUA. And then the question is really just what's their weekly benefit amount? Because this is a newer issue and seems to involve a question of interpretation, I would encourage you another moment. I mean, as we said early on, please don't hesitate to contact us with questions on any topic, but certainly if you take a case with this issue involving self-employed individuals, please let us know. It's another area where we're trying to do some advocacy with Employment Security to correct some of what we believe are incorrect determinations. The next question to ask yourself and work through with the client: is there any basis to remand for eligibility in another program that would remove or decrease the overpayment? So let me give I think a common example. Let's say someone started off receiving state UI benefits. They're now determined overpaid. Maybe it was determined they voluntarily quit their job. We've analyzed the facts and the standard for voluntary quit, and we've determined that yes, it was a voluntary quit. They were not eligible for regular UI. That doesn't mean all hope is lost. The next question we would ask ourselves is, should the client have received PUA? Maybe they quit because their child's school closed in end of March, early April, or their daycare closed and they had no other alternative daycare. Maybe they quit because they had to self-quarantine because of their underlying health conditions. So even though they weren't eligible for regular state UI, they have a basis for eligibility for PUA. And if they're able to successfully apply and they're determined eligible for PUA, that will often wipe out or significantly reduce the overpayment, because what we're arguing is that that the agency just improperly handled the case from the beginning. When the person applied, they should have been denied UI and moved right into the PUA program. And the reason that's significant is because this could end up reducing the overpayment determination for the FPUC and lost wages assistance program benefits. Those are the extra $600 per week and the extra $300 per week that people received, because the receipt of those benefits are conditioned on receipt of the sort of main programs, the state UI or PUA or PEUC. So if someone gets an overpayment of state UI, it's going to include the portion of state UI benefits and say the portion of FPUC benefits. But if the person was actually eligible for PUA during that time period, then there is no FPUC overpayment because they would have gotten those same FPUC benefits even if they had been properly determined eligible for PUA in the first instance. Now you do want to note, if you have a case involved and you're looking at eligibility, where this is involved and you're looking at eligibility for the different programs, you do want to pay attention to the differences in how the weekly benefit amount is calculated, because there may be a difference in that. For example, to give one quick common example, someone who initially received state UI benefits could have been eligible for less than $168 per week, but if they were should have been determined eligible for PUA, the minimum they could receive is $168. So in that instance, the person should have actually received more benefits. Not only were they not overpaid, but they were underpaid. But it cuts both ways, because if the person was initially determined eligible for, say, PUA, let's stick with the self-employed example from a moment ago, say they were approved for PUA based on their gross earnings, their gross income in 2019, and they later submit their net income for 2019, which is less, their weekly benefit amount is going to be reduced. So they were still eligible for PUA, but they were overpaid because the weekly benefit amount was improperly calculated and wasn't calculated on their net earnings. I think we're getting close to the end here. Maybe since I want to be respectful of people's time, Ginny, I know this wasn't the initial plan, but maybe I'll pause here to ask if there's any questions based on what we've been talking about with the anatomy of the case. I think that what we've covered so far is probably the most important.
Sure, I think it's a good point to see if people have some questions. And again, if you think of questions afterwards, I'm sure Ray or Steve will be happy to answer.
Absolutely. As Ginny said, we're happy to share our contact. I don't know that I remember to include our phone numbers on the last slide, but our email addresses are there. And Ginny and the staff at Pro Bono have our phone numbers. So certainly we're happy to address any questions you think of later or that come up again in the context of a case when you come back and reference these materials. So I'll try to move through these last few slides. Oh, sorry, is someone gonna?
This is Ginny. And maybe this was in the original training. We didn't talk about this today at all, but I'm assuming that all of the hearings, and even though they're not going to be starting in January, they're all telephonic.
Yes, yeah, thank you. I did think of that actually early this morning, that I didn't put that in the slide, and I meant to include that. Because of the pandemic, Ginny is correct. All of the hearings are done telephonically. Employment Security is not using any sort of video conferencing. I know some other state agencies are using platforms like WebEx, and I think the courts are using WebEx. Employment Security is doing hearings by phone. They generally last between 30 and 45 minutes unless there's a complicated issue involved. And the claimant and you will be sent a form after you've, one of the forms that you would file if you were going to represent a claimant, and I think I have a link to the forms later on in the slides, is the representation form. And after you file that, you would eventually receive an information or another notice that asks you to provide the best phone number to be reached hearing. And Steve, I just want to make sure I'm correct here. I believe it's important that the client and the representative provide a good phone number, because Employment Security calls us. We don't. There's no call-in number or conference number that's distributed.
That's correct.
And part of the reason I wanted to double check with Steve is because we had a ton of hearings. A lot of the cases up until this point in time have resolved without a hearing, as Ginny mentioned early on in the presentation. And overpayment cases can resolve without a hearing sometimes too, if the facts are really clear and the legal argument's pretty strong. It's possible sometimes to talk to the appeals unit and resolve an issue without a hearing. But we're just starting to do more and more hearings now, whereas early in the pandemic, we were not doing as many. So only a handful of our advocates have actually gone to hearings recently. So I'll just try to keep moving through the slides, but please feel free to type questions as they come up, and I'll be mindful of the time and look. You'll want to ask yourself if the client is eligible for any retroactive or ongoing benefits if the appeal is successful. So when clients receive a determination of overpayment, many of the clients who are contacting us, they were still receiving benefits at the time the overpayment determination was made. So the determination not only leads to an overpayment amount and a debt, but it was also the reason their benefits stopped and were terminated. And so if we're able to successfully appeal the determination, it could lead to the claimant regaining eligibility and receiving retroactive benefits back to the date their case was terminated. And this can be really significant, again, for many of the claimants who were relying on unemployment as their primary means or their only means of support. Again, asked some questions here in this next bullet. If there's no basis for eligibility, can the client seek a waiver? We kind of covered that in the earlier slides. I just put some reminders here of what we talked about, again, is just for the flow of the presentation. But since we covered that, I'm not going to spend a lot of time going through those. And then again, if the overpayment was upheld and waiver is unsuccessful, can you seek a claim compromise? And then if a claim compromise is unsuccessful, what would be a reasonable repayment arrangement? I put a bullet here if you're working with a client who's in a really tough situation, and you can always, should always ask us if you have any questions again, or you could refer the client back to us if they're having other issues. But here are some of the agencies they could be referred to and entities if they need to access other social safety net programs if there really is no hope for obtaining unemployment benefits given their circumstances. Many of the clients will be eligible for those other programs anyway, but just a good reminder if they're in a difficult situation to refer them to those agencies. And then, of course, there's various appeal rights that folks have if they lose a hearing or they're denied a request for a waiver or claim compromise. So would want to be mindful of evaluating the merit of any further appeal at each stage. I don't know that we've talked about this with Ginny, Carolyn, and Lila, but certainly if you could not evaluate or handle that further appeal, I think it would be appropriate to refer them back to NHLA and LARC. We would sort of treat it as a new issue since it's a new phase of the case and evaluate it for representation at that time. But certainly if you wanted to stick with it, that would be fantastic, and we would try to help answer any questions and provide you support in doing that. A quick note about collections of overpayments and interest on overpayments. Usually employment security can recover overpayments by offsetting future benefits, which we've talked about, intercepting federal future tax returns, garnishing wages, or putting liens on real property. Most of those collection activities have been temporarily suspended during the pandemic, except for benefit offsets. But one issue you'll probably hear of if you take a case is clients continue to receive notices threatening collection activity. Part of the problem is because there's such a delay in processing the appeal requests, some of these notices are being issued automatically by the computer system, and our understanding is that it's very costly and a lot of work to make certain changes to employment security's computer system. And so they created a new notice that they are manually sending out to anyone who received a notice of overpayment to advise them that the collection activities have been suspended, and if they've requested an appeal, they can ignore those collection notices. But it causes a lot of anxiety for clients because the notices are constantly, saying if you don't pay by X date, we could put a lien on your house, etc. Or they see the balance growing because the interest is adding up. And that leads us to another point where another piece of advocacy we're trying to do with employment security is around interest on overpayments. Under the state statutes and regulations, interest accrues at 1% per month. If the client pays the overpayment balance in full within 60 days from the date the final decision is mailed, they won't be liable for the interest. And a final decision will depend on what point they are in the appeal process. So if they got the initial notice of overpayment and they didn't appeal and didn't seek a late, file a late appeal request for good cause, that overpayment notice could be the final decision. But if they're going through the appeal process, then the final decision would depend on, would be the hearing decision or whatever decision is issued at the appropriate stage of appeal. One issue we've been trying to sort out with employment security is when, how the interest is sort of backdated. Does interest start counting from the date the initial notice is sent out, or should interest start counting from the date the final decision is mailed out? And we haven't been able to nail down exactly how that's done. We would argue, especially because of the delays in the appeal process right now, that no interest should apply until the date the final decision is mailed. But what we're concerned about is that interest goes back retroactively to the date of the initial notice. So this is really problematic because of the delays, because you could have someone who's pursuing their right to appeal, and maybe it's not the strongest case, but maybe you can see some argument to be made, but they're not going to have their appeal till January or February, and they got the notice of overpayment back in September or October. If they lose that appeal, and employment security disagrees with our interpretation of the regulation about interest is going to apply back to the date of the notice in September, October. So you're dealing with several months of interest, and most of our clients are going to struggle to pay any amount of overpayment, let alone one where the balance is growing fast. And when you're talking about overpayments of $15,000, $20,000, the interest adds up quickly. So just something to be aware of. It's not something that would necessarily come up in the context of your appeal, but wanted to flag it because clients have a lot of questions about it. And also just to note, it's something we are working on. We really believe that we're only one of 15 states that applies interest on overpayments. And we believe during this time, especially, that interest should be suspended, particularly when you're talking about a client who wasn't at fault for causing the overpayment, and it was an agency error, but the client is on the hook for the overpayment because it can't be waived due to the provisions that apply in the CARES Act or otherwise. They're being punished for a mistake that they didn't cause. And so really, from my personal perspective, it's what purpose is the interest serving? It's not a punitive purpose because they weren't at fault and they have none of the blame. And it's not going to get them to pay faster because they literally can't pay. It just wanted to make a note about that. We don't need to belabor it, but it's a significant point of anxiety and concern for clients dealing with these cases. So here's just some helpful resources. I realize we're over time. I apologize. We have some links to the forms, the email address for the appeals unit, link to the statute and regulations compiled on Employment Security's website. And then at different times, I've made reference to the U.S. Department of Labor's guidance and tried to cite to them where I could here's a link to the directory where you can search for that guidance. And I've included in these bullets the guidance that I think we have been referencing the most over the past few months. There are others, but these are the ones that I kind of have at the ready to pull up when we're dealing with questions. And if you have any trouble finding these or the others, please don't hesitate to ask. We've been trying to save them as we become aware of them. But it's also worth checking because there could be new guidance that has come out that we're not aware of. We tend to kind of we find out about the guidance as we're doing research on a particular issue. So if we haven't had the issue come up, we may not realize the new guidance is out there. And I think that officially ends our presentation. So I really thank you to all who were able to stick around and for your interest. I really hope this was helpful. I know it's a lot of information. I hope it wasn't too much in the weeds. I tried to cover the most important points that, you know, when you have a case, you could go back and reference the slides to find the citations or to find the, you know, help issue spot and know where to look. And of course, again, I know made it repeated a lot, but please, as you go back to this slide PowerPoint presentation, as you're handling a case, don't hesitate to contact us for follow-up. But with that, I'll stop talking. And if anyone does want to hang around to ask questions, I'm happy to stay on for a few more minutes to try to answer questions or make some clarifications.
Ray, I want to join the others who, if you look at the chat, are thanking you for your presentation today. I think it's been really, really helpful, and it's certainly for the staff at Pro Bono to have NHLA as a resource to join with you and Lark is allowing us to help people who otherwise, as you said, your resources can get maxed out. So we're able to help people who otherwise might not have gotten assistance, and just learning the various consequences of people losing benefits, having overpayments. It's really such an important work for people to be engaged in. So really thank everybody who is volunteering to take one of these cases and help out somebody.
Yes, it's been a really great collaboration for us. Couldn't agree more. And so want to again extend thanks to the folks at Pro Bono and for all of you and those not in attendance who are committed to this work. We know a couple of people have, I think, or at least I know I'm one person who's taken on multiple cases, and so we really, really valuable your time and your efforts.
I do have a question about when the recording may become available.
Oh, sure.
And I will need to check in with Doreen. I'm not sure about that. That will be in this in her department's hands, but I would imagine it's not going to take all that long. And what we can do too is send out an email to those of you who attended to let you know when it becomes available. And I know, Courtney, you have one of these cases. So any other questions or comments? Again, want to thank Ray. Thank you, Steve, too, for being available.
Oh, sure, Ginny, and I thought while people are still on and for the recording, maybe I'll just make a plug. You know, we really do want to try to help make this, you know, approachable for folks. So please let Ginny and Caroline and Lila know if there are any other trainings, any other information that would be helpful. We'd be happy to consider that and try to put something together. So just wanted to plug that while people are still on.
Thank you. So I think then, unless anyone has anything else they wish to add at this point, as they say, it's a wrap.
Great. Well, thank you, everyone.
Take care.